All right, good afternoon, everyone, and welcome to this webinar training titled MAGS 101 for Circuit Court States Attorneys and Parole and Probation Orientation. My name is Catherine Pembroke. I'm the Administrative and Training Coordinator for the Maryland State Commission on Criminal Sentencing Policy, also known as the Sentencing Commission, or the MSCCSP for short. Now, the sentencing guidelines play a significant role in supporting fair and proportional sentencing practice. Accordingly, your participation in this training and staying up to date on the sentencing guidelines is important because it helps to promote the consistent application of the guidelines. So before we get started, I just want to go over some general webinar housekeeping. I know we're all familiar with Zoom, but I did just want to note that we are asking participants to remain muted throughout the course of the presentation, just to ensure that we get through it in a timely manner. But that said, we certainly encourage questions. So if you have any questions throughout the course of the presentation, please submit those through the chat box that you see here. I have two colleagues here with me this afternoon, our research director, Stacy Najeka, and our program analyst, Sarah Bowles, and they will be happy to answer any questions that you have. If you are able to send your question through the entire group, we certainly encourage that just so everyone can benefit from seeing the question as well as the answer. But that said, if you don't feel comfortable sending your question to the entire group, that's fine. Just make sure you send the message directly to either Stacy or Sarah. So we have a lot to cover this afternoon. Let's go over today's agenda. So many of you are probably somewhat familiar with the guidelines themselves, but we thought it'd be helpful to start the presentation by providing some background information about the purpose and goals of the MSCCSP. Then we're going to get into the various sections of the guidelines worksheet and how to calculate them. We're also going to take a look at some special applications that adjust the calculation of the guidelines in certain scenarios. And then we're going to wrap up with a live demonstration in the Maryland Automated Guideline System, which we refer to as MAGS, as well as a focus on some upcoming guidelines related updates. Okay, so let's begin with a brief history of the guidelines and the Sentencing Commission in Maryland. So Maryland was actually one of the first states to initiate a sentencing guideline system. The guidelines were first introduced by the judiciary. In April 1979, the Sentencing Guidelines Advisory Board, which was formed by the judiciary, approved a system of voluntary guidelines to be piloted in 4 jurisdictions. These sentencing guidelines were then approved for statewide use in the circuit courts starting in 1983. The guidelines in Maryland were in effect statewide for about 15 years with oversight by the judiciary. And then in 1999, the legislature decided that a permanent independent sentencing commission should be created to have oversight over the guidelines. Now, the enabling legislation that created the current day Sentencing Commission outlines a statement of intent for the MSCCSP in Criminal Procedure Article Section 6-202 that includes 6 goals. First, that sentencing should be fair and proportional, and that the sentencing policy should reduce unwarranted disparity, including any racial disparity, and sentences for criminals who've committed similar crimes and have similar criminal histories. Second, that sentencing policy should help citizens to understand how long a criminal will be confined. Third, sentencing policy should preserve meaningful judicial discretion and sufficient flexibility to allow individualized sentences. Fourth, that the sentencing guidelines should be voluntary. Fifth, the priority for the capacity and use of correctional facilities should be the confinement of violent and career criminals. And finally, that sentencing judges in the state should be able to impose the most appropriate criminal penalties, including corrections options programs for appropriate criminals. Now, the Commission has a few primary responsibilities to help to address these goals. The first responsibility is to implement and maintain the state's voluntary sentencing guidelines. And this is accomplished through the second major responsibility, which includes collection and maintenance of an extensive database, which is assembled via the data submitted on the sentencing guidelines worksheets. Now, the Commission uses the guidelines data to monitor circuit court sentencing practice. It also examines sentencing patterns and reasons for departures for specific offense categories and within individual cell ranges. And by doing so, we're able to consider adopting changes to the guidelines when necessary. And finally, the Commission is also responsible for providing training to criminal justice practitioners to promote the consistent application of the guidelines and accurate completion of the guidelines worksheet. Now, just to give you an idea of who exactly makes up the commission, so the commission was created as a balance board of 19 members from all three branches of government. The commission is currently chaired by Judge Brian DiLeonardo from the Circuit Court for Carroll County. Membership also includes 3 additional judges, including representatives from each of the 2 trial courts and 1 appellate court's representative who serves as the chief judge's designee. The remaining 15 members include a cross-section of criminal justice officials from the other 2 branches of government, as well as 2 public representatives. Appointed members serve terms of 4 years and are eligible for reappointment. Now, the MSCCSP makes decisions with respect to the guidelines after deliberating with the many stakeholders that encompass the Maryland criminal justice system, most, if not all, of its constituencies being represented here on the commission. So let's get down to the basics here. What is the purpose of sentencing guidelines? Now, the sentencing guidelines are a mechanism to encourage proportional sentences. The primary goal of the guidelines is to promote consistent, fair, and equitable sentencing practices, whereby offenders who are convicted of similar offenses with similar criminal histories, they're being treated and sentenced alike. The Maryland sentencing guidelines were designed to systematically account for the most common variations in offenders and their offenses. They help to achieve proportional sentencing by identifying and assigning weights to core objective factors for consideration by judges in making sentencing decisions. The guidelines account for the most common, but certainly not all, characteristics of an offender in his or her crime that are most relevant to the sentencing decisions. And they help to provide a framework to allow judges to consistently assign the same value or score as their colleagues around the state for each of these legitimate legal factors. So let's discuss some of the basic principles of the sentencing guidelines. The first being that the sentencing guidelines in Maryland are voluntary. So judges may, at their discretion, depart from the guidelines. The voluntary nature of the guidelines emphasizes that they are designed to be a tool to help inform sentencing decisions, and that they are intended to complement rather than replace the judicial decision-making process. They're also intended to be primarily descriptive. So in other words, the guidelines are informed by analysis of actual sentencing practices and are designed to illustrate to judges how their colleagues are sentencing on average for a typical case. The descriptive nature of the guidelines means that they are not intended to be static, but rather they're dynamic, and the guidelines may be amended when the data indicates that sentences are not consistent with the recommended ranges. And then finally, the basic principle is that the Maryland guidelines are generally limited to cases that originate in the circuit court. So let's take a closer look at the scope of the sentencing guidelines worksheet. So you can see the sentencing matters on the left-hand side. These are types of scenarios that would require a guidelines worksheet. So again, circuit court original sentencings, jury trial prayers and appeals from the district court, they are guidelines eligible, but only if a pre-sentence investigation is ordered. And in that case, the parole and probation investigator is initiating the guidelines worksheet. Probation before judgments that occur in circuit court original sentencings. Now, reconsiderations that involve a crime of violence and 3-judge panel reviews, they also require a guidelines worksheet if there is an adjustment to the active sentence as a result of that hearing. Now, on the right-hand side, these are sentencing matters that are still handled by judges in a circuit court, but they are excluded from guidelines coverage. So these include jury trial prayers and appeals from the district court, again, unless a PSI is ordered, offenses that carry the no possibility of incarceration, violations of public local laws or municipal ordinances, probation violation hearings, criminal non-support and criminal contempt, juvenile court adjudications, and then district court sentencings are also excluded from guidelines coverage. So on a related note, I just want to note that we've worked with MDEC and JIS to implement a guidelines eligible case indicator on the MDEC dockets. So you can see here's a screenshot of the criminal docket for Anne Arundel County. This occurred earlier in the month on September 7th. And you can see that the guidelines eligible cases are marked with this MAGS yes indicator, indicating that it's a guidelines eligible case. So I did just want to point out again that we worked with GIS to create this guidelines eligible case indicator. If you think it'd be helpful to look to dockets for upcoming cases, just to help remind you of whether or not a guidelines worksheet would be required, we certainly encourage you to check this out on the docket. Now, that said, we worked really hard to fine tune the criteria, but it's possible that a case could end up being flagged as eligible when perhaps it may not be. So just using the criteria that we talked about on the previous slide, just keep that in mind when referring to this docket. But again, we did work hard to fine tune that criteria, so it should be very accurate. So we talked about this a little bit, but I just want to emphasize again how exactly we utilize the guidelines data. So generally speaking, the data is assessed to review sentences and helps to inform the commission whether changes to individual cell ranges or offense seriousness categories are warranted. The data is also used to monitor compliance and to see how often judges depart from the guidelines for specific offenses and offense types. And then finally, the data is also used to inform the legislature of sentencing patterns for specific offenses or offense categories. So every year we do publish an annual report. It details various sentencing trends throughout the state of Maryland. So if that's something that may be of interest to you, all of our annual reports are accessible from our website. So you can feel free to check them out there. And again, just want to emphasize that how important it is that we're getting as much guidelines data as possible to help inform these sentencing decisions. Now, turning towards guidelines worksheet completion, I just want to quickly discuss the primary purposes of the guidelines worksheet itself. Now, the first purpose of the worksheet is to inform the judge of the guidelines prior to sentencing. So Criminal Procedure Article 6-216, it indicates that the court shall consider the guidelines at sentencing. And in order to do so, a guidelines worksheet must be prepared. Criminal Procedure Article 6-210 then requires that the commission collect sentencing guidelines worksheets, automate the information, and monitor sentencing practice. Now, continuing on with guidelines worksheet completion, I want to start by defining what we constitute a single versus a multiple criminal event for guidelines calculation purposes. Now, a single criminal event is defined as one or more crimes committed in the course of the same transaction, whereas multiple criminal events means that more than one criminal transaction was committed over a period of time. Now, multiple criminal events being sentenced together, they may have occurred on the same date or different dates. But generally, offenses that occur on different dates are almost always considered separate criminal events. Now, moving on to a sentencing event. Now, a sentencing event is defined as a sentencing disposition or hearing for an individual defendant conducted in front of one judge on the same day. So when there are multiple criminal events, again, they're often offenses that may have occurred on different dates. So they may be identified by their own unique case number. But if they're sentenced by the same judge on the same day, they constitute one sentencing event. And if this is the case, then only one set of guidelines worksheets should be completed for all counts in the sentencing event, which would then result in one overall guidelines range. And when we get to the MAGS portion of the webinar, I'm going to show you how to properly initiate a multiple criminal event, single sentencing event scenario. So the last thing I just want to point out is that merged offenses are not included on the sentencing guidelines worksheet and should not be considered in calculating the guidelines range or in any of the worksheet computations. Now, I know that this text is a little small here, but I want to take a look at an example to illustrate how one sentencing event may include multiple criminal events. Now, this shows two criminal events being sentenced in front of the same judge on the same day. If we look to this upper left-hand corner here, we can see a distribution of PCP that was committed on July 10th of 2020. It has its own date of offense with its own unique case number. And then jumping down to the second worksheet in the lower right-hand corner, we have an assault first degree from January 25th of 2021. Again, has its own unique case number with a different offense date than the worksheet in the upper left-hand corner here. Now, by guidelines rule, each separate criminal event should correspond to their own guidelines worksheet. So even though there may be one convicted offense per criminal event, it's still correct for them to be reflected on their separate worksheets. You'll see an individual guidelines range reflected for each convicted offense. However, there is still one overall guidelines range calculated between them, given that they are sentenced as part of the same sentencing event. And again, we'll take a look at this when we get to the MAGS portion a little bit later on. So the next section of the guidelines worksheet that we want to discuss is convicted offense information, which is pretty self-explanatory. It's the sections that you see highlighted here. It's where we capture the convicted offense based on what you select in the Maryland automated guideline system. After selecting that offense, the CJIS code, the statutory maximum, if there were any mandatory minimum, and then the case number corresponding to the convicted offense, that will populate on the worksheet here. Now, in the upper left-hand corner where you can see it says at this sentencing, the number of convicted offenses and criminal events, I just want to reiterate and emphasize when you do have either multiple convicted offenses, they may be multiple criminal events, you want to make sure that you're correctly inputting the number of criminal events in MAGS so that it knows how to properly calculate the overall guidelines range. So again, just wanted to point out those boxes so that you can pay attention to it and make sure that the proper number of convicted offenses and criminal events is reflected on the worksheet. Now, the last column that I want to point out here, it has the Roman numeral equivalents of 1 through 7 as the header. Now, that's the seriousness category column. So I'm going to divert from the worksheet for 1 second to talk about how that seriousness category plays a critical component to guidelines calculation. So again, most of you are probably familiar with the general framework, but I want to give a brief overview of the basic premise of the guidelines. So Maryland has 3 separate sentencing matrices. We have one for property that you see here, we have one for drug offenses, and then another for person offenses, those typically involving victims, such as assault, robbery, as well as the weapon-related offenses. Now, the guidelines were designed to take both offender and offense characteristics into account. So you can see on the left-hand side here, the first column represents the offense seriousness category. Now, each offense in Maryland is ranked based on its seriousness, with 7 being the least serious to 1 being the most serious. And we can see for property offenses, those offense seriousness categories range from a 7 to a 2. Now, the top row here, this represents the offender score, which we'll get into a little bit later on, but it captures basic components of an offender's prior criminal history. So let's just walk through a basic example of how guidelines would be calculated for a property offense. Let's say we have an offender who has no prior criminal record. So they have an offender score of 0, and say they've been convicted of theft less than 100, which is a seriousness category 7 property offense. So referring to the matrix here, we can see that the recommended guidelines range would be probation to probation. So again, that's just a basic example of how guidelines are calculated. And again, the example just shows and emphasizes the importance of the seriousness category. Okay, so returning to the worksheet calculation process, the next section we're going to discuss is the offense score section. Now, the offense score is calculated for person offenses only. We just talked about how those are offenses that typically involve victims as well as weapon-related offenses. Now, the offense score is a summary scale ranging from 1 to 15, and it measures the seriousness of a person offense based on 4 components. We have part A, which is the seriousness category. So just based on the seriousness category of the underlying offense, we can see that X number of points are scored. Part B, victim injury, C, weapon presence, and then D, special victim vulnerability. So again, just jumping back to the seriousness category here, we can see that it ranges from 1 point for a seriousness category 5 through 7 offense, all the way to 10 points for a seriousness category 1 offense. Now, with regards to the offense score and the seriousness category of an offense, it's also important to note that in general, any conspiracy, attempt, or solicitation is assigned the same seriousness category as the underlying offense. Now, with that being said, there are a few exceptions that come into play with some of the more serious offenses. For example, attempted first-degree murder is a category 2 offense, whereas first-degree murder is a category 1. And the same would be true for attempted rapes. Again, some of those more serious offenses. So if you ever have a question about the seriousness category, you can always refer to our offense table. And for some of these more serious offenses, you'll see the attempts, conspiracies, solicitations, they're listed as separate entries in the offense table. So you would just want to make sure that you're selecting that proper offense entry. Now, moving on to victim injury. So, victim injury is defined as reasonable proof of injury, which may be physical or psychological, the cause of which is directly linked to the conduct of the defendant in the commission of the convicted offense. So, 1 point is scored for a non permanent injury, 2 points are scored for a permanent injury or death. Now, psychological injury shall be based on confirmed medical diagnosis or psychological counseling or treatment, and is presumed not permanent unless otherwise demonstrated. And physical injury shall also be more than minimal. Now, I will say with regards to victim injury, the instructions in our manual do get into a little more detail than what I'm providing here, but there is still some gray area when it comes to scoring victim injury. So, for example, we've been asked if there was a victim of a stabbing and the victim sustained a scar as a result of that stabbing. Would that scar constitute a non-permanent injury or a permanent injury? And the instructions in our manual just don't get into that level of detail. We can't account for every scenario that comes about. So with that being said, it's ultimately at your discretion as to the number of points that you score in those somewhat of a more gray area scenarios. And if the defense happens to disagree, that can be brought to the judge's attention at sentencing, and ultimately the judge will decide whether an injury would constitute a non-permanent or permanent injury or no injury. Now, moving on to weapon presence. Weapon presence is defined as the presence of any article or device that reasonably appears capable of causing injury. So 1 point is scored here for a weapon other than a firearm, such as a knife or a BB gun. 2 points are scored for a firearm or an explosive. So I also want to note that when calculating the offense score, a judge may include factors known to the judge, even if they are not within the scope of the convicted offense. So, for example, if a defendant is charged with armed robbery but pleads to robbery, points may still be awarded for firearm or weapon presence in that type of scenario. So that's just something to keep in mind. All right, so before we get into Part C of the offender score, which is special victim vulnerability, I want to start with a poll question here. I'm going to populate it in a moment here. And the question is asking, would a victim who was known by the defendant to be pregnant meet the criteria for a vulnerable victim? So I'm going to go ahead and launch this poll. And if you can just go ahead and make a selection, these poll questions are just a good exercise to highlight some common questions that we get from practitioners. And your answer is anonymous. Again, it's just an exercise. And I'll give everyone just a couple seconds to make a selection, and then we'll take a look at the final answer. So again, would a victim who is known by the defendant to be pregnant meet the criteria for a vulnerable victim? Okay, and it looks like we have a good portion, their answer locked in. So let's go ahead and share the results. So we have 81% thinking yes, with 19% thinking no. So let's go ahead and take a look at the answer here. And the answer is yes, it would constitute a vulnerable victim. So let's take a closer look at the criteria here. These are the factors used to determine if a victim is especially vulnerable. So if the victim's younger than 11 or 65 years old or older, or if they have a temporary or permanent physical or mental disability, including an individual who is physically or mentally limited in a material way. Now, examples of a temporary physical or mental limitation include, but are not limited to, instances in which the offender knew or should have known the victim was pregnant, unconscious, asleep, or intoxicated. So again, if the victim meets any of these criteria, you would score 1 point for special victim vulnerability, wrapping up the offense score calculation. Okay, so moving forward to the offender score section. So we talked about this a little earlier when we went through the example. The offender score is a summary scale ranging from 0 to 9, and it measures an offender's criminal history taking into account 4 factors. That being Part A, relationship to the criminal justice system when the instant offense occurred, B, juvenile delinquency, C, prior adult criminal record, and D, prior adult parole and probation violations. Okay, we're going to do another poll question before we look at Part A in a little more detail here. So true or false, 1 point should be scored for Part A of the offender score, relationship to the criminal justice system when the instant offense occurred, if the defendant was on pretrial supervision at the time the instant offense occurred. I'm going to go ahead and launch that poll. And go ahead and start making your selections. I'll read the question one more time. So true or false, only one adjudication. Oops, I'm so sorry, that was the wrong question. My apologies. Let me see if this is the right one here. Okay, my apologies. That one didn't make it into the poll. So let's just go over the answer here. And the answer is false. So let's look at that Part A special relationship to the criminal justice system when the instant offense occurred. Now, just as a reminder, an offender should receive 1 point if in the criminal justice system as a result of an adjudication of guilt at the time the offense was committed. So for example, if the defendant is currently on parole, probation, etc., at the time the instant offense occurred, 1 point would be scored for Part A. Now, generally, when a defendant's on pretrial supervision, they have not yet been adjudicated guilty, which is why that wouldn't meet the criteria of criminal justice supervision. But that said, it's been brought to our attention before that it is possible for someone to be adjudicated guilty and still on pretrial supervision pending sentencing. So if that were the case, and then the defendant picked up the instant offense after been adjudicated guilty pending sentencing, 1 point would be scored here. But generally, being on pretrial supervision would not constitute criminal justice system involvement. Okay, so moving on to Part B, juvenile delinquency. Now, 0 points would be scored for juvenile delinquency if the offender was 23 or older by the date of the most recent instant offense, or if the offender has 0 findings of a delinquent act within 5 years of the date of the most recent instant offense. 1 point is scored if the offender is under 23 and has 1 or 2 findings of a delinquent act within 5 years of the date of the most recent instant offense. And then 2 points scored if the offender is under 23 and has had 3 or more findings of a delinquent act within 5 years of the date of the most recent instant offense. Now, just providing some further instruction regarding scoring juvenile delinquency. So this is similar to how the adult prior record is calculated, but only 1 finding of a delinquent act, that is finding of fact sustained at an adjudicatory hearing, should be counted for a single adjudicatory hearing. Meaning that if there are multiple findings of a delinquent act, if they relate to a single adjudicatory hearing, the individual completing the worksheet shall count only 1 finding of a delinquent act. All right, so moving on to Part C, the prior adult criminal record. Now, aside from a few exceptions that we have further noted in our manual, generally the prior adult criminal record includes all adjudications preceding the current sentencing event, whether the offense was committed before, during, or after the instant offense or offenses. All right, so I have another poll question here. I'm going to hope that this one is able to work, but true or false, only 1 adjudication per criminal transaction should be counted towards the prior record score. I don't know that I'm going to be able to launch that one again. Let's see here. Nope, but I'm going to go ahead and share the results that we did have at that time. So this was pretty split. 40% think true, 60% thought false. So let's go take a look at the answer here. And the answer is true, that only 1 adjudication per criminal transaction should be counted towards the prior record score. So let's take a closer look at calculating the prior adult criminal record, because this is probably the most complicated component of the offender score calculation. So I'm going to walk through the steps, and then we're actually going to go through a hypothetical prior criminal history and talk about how it should be scored. So the first step is to identify the offense with the highest seriousness category for each prior criminal transaction. So if you have multiple adjudications stemming from the same transaction, you're only going to identify the offense with the highest seriousness category. That's going to be the only offense counted towards the prior record out of that criminal transaction. Step 2 is then to count the number of offenses in each seriousness category using only the offenses that you identified in step 1. Then you would refer to our criminal record matrix table to identify the corresponding prior record level. Before we take a look at it, I do want to note that Maryland allows for what we refer to as the criminal record decay factor, meaning that if a defendant has remained free of criminal justice system involvement, so meaning they've been off parole, probation, mandatory supervision, etc., for 10 years prior to this instant offense, the criminal record should be reduced by 1 level, meaning if it's originally scored to be a moderate, as long as the defendant's criminal history meets this criminal record decay factor criteria, it would then be reduced to a minor record level. So here's a screenshot of a prior adult criminal record matrix, and let's walk through a hypothetical criminal history scenario. So let's say we have a defendant who was convicted of assault second degree, which is a category 5, as well as a wear, carry, transport of a handgun, which is a seriousness category 7, convicted of those 2 offenses on October 1st of 2013. Now, again, since only 1 adjudication per criminal transaction should be counted towards the prior record, you would be counting the assault second degree, since that is the more serious offense. Then the defendant was convicted of burglary second degree, which is a category 4 property offense, which occurred on 7/28 of 2016. And then finally, a resisting arrest on December 12th of 2020. Now, out of all of these prior adjudications or convictions that you're counting towards the prior record, it's the burglary second degree, which has the most seriousness category, that being a seriousness category 4. And there's only 1 seriousness category 4 conviction among all of the convictions. So looking to our matrix here, we would look to the seriousness category column on the left-hand side. I'm going to look to seriousness category 4, since that's the most serious conviction that I have. And then I'm going to look at this first column here, which is number 1, given that there's only 1 seriousness category 4 conviction. So looking here, we can see that initially the defendant's prior record level would result in a moderate record and then would jump to a major if combined with 2 or more offenses in categories 4 through 6 or any 6 offenses. So hopefully that was helpful to kind of walk through a scenario. Again, I know that this can be a bit of a complicated component of the offender score. If you ever have questions about scoring the prior record, please always feel free to contact our office, and we're happy to help score that with you. All right, so then we're going to wrap up the offender score with prior adult parole and probation violations. So 1 point would be scored here if the offender was ever adjudicated in violation of parole or probation, or was convicted of an offense while on parole or probation, unless the adjudication or conviction arose from the offense or offenses of the sentencing event. Okay, now moving on to the guidelines range section on the worksheet. So when viewing the worksheet, you'll see there's space for an individual guidelines range for each convicted offense, as well as the overall guidelines range for the sentencing event. So based on how you enter information into the Maryland automated guideline system, the application will calculate the recommended guidelines ranges for you. Now let's just take a look at a couple of examples of how the guidelines range is adjusted due to special circumstances in a case. So starting with the multiple victim stacking rule. So here's an example of where the overall guidelines range is adjusted due to a case involving multiple victims within a criminal event, which we often refer to as our guideline stacking rule. Now, in this type of case, the guidelines range for each individual offense is still calculated as normal, but instead of using the highest of the lower limits and the highest of the upper guidelines limit, instead, the highest of the lower limit is taken, and the upper limits for each offense involving a unique victim are then added or stacked. So if there are multiple offenses per victim, you would only want to stack the upper limit for the most serious offense. So looking at this example here, we have a defendant who was convicted of 3 counts of assault second degree, each involving a separate or distinct victim. And we can see, for those of you familiar with MAGS, that the multiple victim stacking rule here is flagged for all 3 offenses. Now, the individual guidelines range is calculated for these 3, that being 2 years to 5 years. Now, for those of you who may have manually calculated guidelines prior to MAGS, generally in a scenario like this, if there weren't multiple criminal events, you'd be taking the highest of the lower limits and the upper limits to get the overall range, which would be 2 years to 5 years. But in this case, you're going to stack the upper limits for each offense involving a unique victim, which increases that overall guidelines range to 2 years to 15 years, to again reflect the fact that there were multiple victims involved in this criminal event. So taking that, let's just kind of recap the criteria for scoring the stacking rule here. So again, there must be a criminal event with multiple distinct victims. There cannot be more than one seriousness category 1 or 2 offense. So for example, if you had 2 murder first degrees or something like that, those would be 2 seriousness category 1 offenses. So you wouldn't be able to utilize the stacking rule in that scenario. Again, only one convicted offense per distinct victim may be used to calculate the overall guidelines. So if you have multiple offenses relating to the same victim, you would just want to stack the offense with the highest, that's the most serious, which would give you the highest upper limit. And again, it's only the upper limits that stack. So taking all of that information, let's look at another poll question here. This is a question we get pretty frequently. So true or false, the stacking rule can only apply towards person offenses. So we talked about person offenses being those that typically in like assaults, robberies, as well as weapon related offenses. Let's go ahead and launch this poll here. Okay, so true or false, the stacking rule can only apply towards person offenses. Just go ahead and make a selection. I'll give you all a couple seconds and then we'll take a look at the answers here. About 3 more seconds. All right, so let's go ahead and share the results here. So we have 73% thinking true and 27% thinking false. So let's go ahead and take a look at the answer here. And the answer is false. So the stacking rule can definitely be applied to property offenses as well. For example, if you have a theft scheme or theft related cases that involve different victims, you can certainly apply the stacking rule in that scenario as well. So it is not limited to just person offenses. And again, that's a common question that we get, which is why I like to highlight it in the webinars, just so you know that you can utilize it in other circumstances other than just person offenses. All right, so wrapping up this particular section with just another sentence enhancement that I want to highlight here. So in this example illustrated here, we show a case where the offender was convicted as a subsequent drug offender pursuant to Criminal Law Article 5-905. So in this example, the offender was sentenced for distribution of cocaine, a category 3B drug offense, and has an offender score of 3. So initially, the guidelines range in this case would have been 3 months to 3 years. However, because this offender was convicted as a subsequent drug offender pursuant to Criminal Law Article 5-905, under that statute, the statutory maximum is doubled, and then by guidelines rule, the guidelines range is then doubled. So it increases from 3 months to 3 years to 6 months to 6 years due to the subsequent offender status. So again, just another enhancement I wanted to point out. And when we get to the MAGS portion, I'll show you all how to apply these enhancements in MAGS. All right, so just wrapping up the last 2 sections of the guidelines worksheet here. In the lower left-hand corner, this is where we capture victim information. These are questions that pertain to the rights of victims at sentencing. And we do ask states attorneys and parole and probation agents to fill out as much victim information as they can prior to sentencing. And I'll reiterate this again when we get to the MAGS portion. And then finally, the remaining fields that you see highlighted here on the guidelines worksheet, these are the sentencing and departure related fields that are typically completed by judges and their designees post-sentencing. So it includes sentence information for each individual offense, the disposition type, whether victim court costs were imposed, etc. Okay, so before we get into the MAGS portion, I want to also go over what constitutes a guidelines compliant sentence. Now, a sentence is deemed compliant with the guidelines if the guidelines applicable sentence, which is defined as the sum of incarceration, credited time, and home detention time, if it falls within the applicable guidelines range. So I just want to note that generally suspended time is not considered when determining if a sentence is compliant with the guidelines. There's one exception involving corrections options, which we'll talk about in a moment here. But generally, it's the sum of incarceration, credited time, and home detention time, whether or not that falls within the applicable sentencing guidelines range. That determines compliance. Now, I also want to note that compliance is calculated by comparing the overall total sentence across all convicted offenses in a sentencing event to the overall guidelines range for that sentencing event. So, for example, it's possible that the sentence could exceed the upper guidelines limit for one offense in the sentencing event, fall below the lower guidelines limit for a second offense, but the overall sentence, when adding together the sentence for both counts, also taking into consideration whether those sentences are running concurrently or consecutively, if they fall within the overall guidelines range for the sentencing event. Now, there are a few qualifiers to consider regarding guidelines compliance, and the first is that effective April 1 of 2021, sentences adjudicated pursuant to an MSCCSP binding plea agreement are deemed guidelines compliant. Now, some of you might remember the former ABA plea agreement disposition type, but it's important to note that that former ABA plea agreement has now been replaced with MSCCSP binding plea agreement. And the criteria for what constitutes a guidelines compliant MSCCSP binding plea agreement has also been revised. And we're going to look at that specific criteria in a moment. But I just want to note that the MSCCSP binding plea compliance rule, it follows the same logic as that former ABA plea agreement compliance rule, which was initiated based on feedback received from the judiciary that binding pleas represent a consensus of the parties and the court within their specific community. So accordingly, the commission felt it was important to define these as compliant sentences. Now, binding pleas are three-party agreements in which the state and the defense present to the court on record an agreement that incorporates a specific sentence. And if the judge accepts that agreement, it becomes binding on the court pursuant to Maryland Rule 4-243 subsection C. Now, following a review of binding pleas in 2020, which included a review of definitions of binding plea agreements from other jurisdictions, an examination of relevant Maryland case law, and an analysis of sentences for guidelines eligible cases sentenced from 2017 through 2019, the MSCCSP agreed that the former term ABA plea agreement is not universally known and should be replaced with the more intuitive MSCCSP binding plea agreement. And further, effective April 1st of 2021, we also narrowed the definition of what constitutes a guidelines compliant plea and adopted language to specify that an MSCCSP binding plea agreement means an agreement to a specific amount of active time, if any, and not merely a sentence cap or range. So in totality, the definition of an MSCCSP binding plea agreement is a plea agreement presented to the court in agreement by an attorney for the government and the defendant's attorney or the defendant when proceeding pro se, that is, a court has approved relating to a particular sentence and disposition. An MSCCSP binding plea agreement means an agreement to a specific amount of active time, if any, and not merely a sentence cap or range. The court has the discretion to accept or reject the plea, and the agreement is binding on the court under Maryland Rule 4-243 subsection C if the court accepts the plea. So I know that was a lot to take in. Let's apply that to some hypothetical sentencing scenarios, and we'll determine if they constitute an MSCCSP binding plea agreement. So let's say the guidelines for the sentencing event are 2 years to 8 years. The state and the defense present to the court a plea agreement to a sentence range anywhere from probation to 2 years. The court accepts this agreement and sentences the defendant to 3 years, suspend all but 1 year. Is this an MSCCSP binding plea agreement? So I'm going to go ahead and launch this poll here. And I'm going to read it again while you all start making selections because I know it's kind of hard. I had to kind of cram it all in there. So let's say the guidelines for the sentencing event are 2 years to 8 years. The state and the defense present to the court a plea agreement to a sentence range anywhere from probation to 2 years. The court accepts this agreement and sentences the defendant to 3 years, suspend all but 1 year. Is this an MSCCSP binding plea agreement? I'll give you all just a couple more seconds to lock in your answer, and then we'll take a look. Okay, let's go ahead and share the response here. So this one's a little bit split. We have 43% thinking that yes, this is an MSCCSP binding plea, with 57% thinking no. So let's go ahead and take a look at the answer here. And no, this does not constitute an MSCCSP binding plea agreement. So just as a reminder, an MSCCSP binding plea must involve an agreement to a specific amount of active time, if any, and not merely a sentence range or cap. So in this scenario, the court accepted a plea agreement to a sentence range, anywhere from probation to 2 years. And this is why it would not constitute an MSCCSP binding plea. Okay, so let's take a look at another kind of common sentencing scenario. Let's say the guidelines for the sentencing event are 1 year to 6 years. The state and the defense present to the court a plea agreement to 5 years, all suspended with credit for 62 days. The court accepts this agreement and sentences the defendant to 5 years, all suspended with credit for the 62 days. Is this an MSCCSP binding plea agreement? All right, I just launched that poll. I'm going to read it one more time. So the guidelines for the sentencing event are 1 year to 6 years. The state and the defense present to the court a plea agreement to 5 years, all suspended with credit for 62 days. The court accepts this agreement and sentences the defendant to 5 years, all suspended with credit for 62 days. Is this an MSCCSP binding plea agreement? Give you all just a couple more seconds here. All right, looks like we have majority, their answers locked in. So here we have 79% thinking yes, 21% think no. So let's go ahead and take a look at the answer here. And the answer is yes, this would constitute an MSCCSP binding plea agreement. So in this scenario, there was an agreement to a specific amount of active time, that being 0, or in other words, no post-sentence incarceration. Therefore, this would constitute an MSCCSP binding plea agreement. So hopefully those scenarios kind of helped tease this out. Okay, so one last scenario. This isn't going to be a poll question, but just something I want to highlight here. So let's say that the guidelines for the sentencing event are 1 year to 5 years. The state and the defense present to the court a plea agreement to a sentence range anywhere from 2 years to 4 years. The court accepts this agreement and imposes a sentence of 5 years, suspend all but 2 years. Now, while this agreement is not an MSCCSP binding plea agreement, right, because it involved a sentence range anywhere from 2 years to 4 years, the sentence is still guidelines compliant, since the guidelines applicable sentence of 2 years falls within the overall guidelines range of 1 year to 5 years. So just want to reiterate that it's still very possible to have a guidelines compliant sentence that is not adjudicated via an MSCCSP binding plea agreement. So again, just hopefully going through those different sample sentencing scenarios were helpful. Okay, so moving on to an additional qualifier to consider, which is the role of corrections options. Now, sentences to corrections options programs. So for example, drug court, residential substance abuse treatment, home detention, etc. They are deemed compliant provided that the initial sentence plus any suspended sentence. So essentially the total sentence, as long as that falls within or above the applicable guidelines range, and the case does not include a crime of violence, child sex abuse, or escape. So this is the one exception I mentioned earlier in which suspended time is considered for determining a guidelines compliant sentence. So let's just take a look at the list of corrections options here. Now, corrections options allow judges to utilize a broader range of alternatives to incarceration while still remaining compliant with the sentencing guidelines. So corrections options include home detention, inpatient residential treatment, inpatient drug or alcohol counseling under a health general article, drug court, participation in any problem-solving court, a sentence with required substance abuse treatment for the possession of a controlled dangerous substance, work release, or weekend or other discontinuous incarceration. And then wrapping up with the last qualifier to consider regarding guidelines compliance, and that is credit for time served. So sentences in which the offender received credit for time served with no post-sentence incarceration, and if the amount of credited time exceeds the guidelines range, those are deemed guidelines compliant. So for example, if the guidelines range is probation to 3 months and the sentence is 6 months fully suspended with credit for 100 days, the sentence is still guidelines compliant, even though the credited time exceeds the upper guidelines limit. Okay, so that wraps up the guidelines compliance portion. Now we're going to move to the Maryland Automated Guidelines System. Before I go in, I just want to show you a couple screenshots. The first being here, our MAGS homepage. So on the MAGS homepage, I just want to point out a couple of instructional and support materials that we have available for you. We have a MAGS user manual. It's a searchable PDF. So if you ever have a question, a MAGS related question, you can certainly refer to this user manual. We also have MAGS instructional videos. We have two. The first is geared towards parole and probations and state's attorneys, and it focuses on initiating a guidelines worksheet, very similar to what I'm about to show you. The second video is geared towards judges and their designees, and focuses on how to enter some sentence information and submit the worksheet through MAGS. So if you ever need a refresher, if you have a new colleague who comes on board and MAGS may be brand new to them, we certainly hold these webinars and trainings throughout the year, but you can also refer them to these instructional videos. They will be very helpful. And then to access MAGS, you would simply just click on this MAGS login button here. Now, before we go into MAGS, I also just want to point out our guidelines calculator tool. Now, our guidelines calculator tool, it's a standalone tool that can be utilized by anyone to calculate sample sentencing guidelines. So you don't need a user ID, you don't need a password. You can access it from our website. The only caveat is that it doesn't save any of the information that you enter like MAGS would. So I know that the guidelines calculator tool, I know that a lot of state's attorneys, parole and probation agents, they may use that tool to calculate sample guidelines, maybe in advance of like plea negotiations. So if you think that would be helpful, that's why I wanted to point out this tool here. The only thing is you will need to remember to officially initiate the worksheet in the MAGS system. But again, if you just kind of want to work out a couple of different scenarios, feel free to utilize the guidelines calculator tool here. You can see that it essentially mirrors MAGS with the first three tabs that are completed prior to sentencing, that being the offender information, offender score, list of offenses. Based on the information that you input, MAGS will calculate those sample guidelines for you. And you can print them out. You can save the PDF to your computer, whatever you'd like to do. Also know that this tool is particularly helpful for defense attorneys as well. Okay, so now we're going to move on to the MAGS demonstration portion. I'm just going to bring up the MAGS login screen here. So bear with me for 1 second while I do that. Okay. So here is our MAGS login screen. And as I'm sure you're all aware of, everyone's user ID, it corresponds to their individual agency or jurisdiction. Now my prefix, everyone's user ID is going to start with a prefix, I should say, that corresponds to their agency and or jurisdiction. So I'm just going to go ahead and enter my prefix and username, as well as my password. And I'll log in here. Okay, so after logging into MAGS, you're going to be brought to our home screen, and it's from the home screen that you can create a new worksheet, or you can view, edit, or delete an existing one. Now, as state's attorneys and parole and probation agents, it's a good habit to get into to search the MAGS system to make sure you're not duplicating a worksheet, particularly with cases that may involve pre-sentence investigations. So for example, it's possible that maybe the state's attorney initiated a guidelines worksheet, later on a pre-sentence investigation is ordered, which typically parole and probation investigators complete the guidelines worksheets for. So both of you would want to make sure you're just searching the system to make sure you don't duplicate a worksheet. Now, I will say, in that scenario I just brought up, if the parole and probation agent searches the worksheet, sees it was already initiated by the state's attorney, go ahead and review the calculation by the state. If you disagree with any calculation, then we ask for the parties to reach out to each other, discuss whatever discrepancy you may see in hopes to coming to a solution so that you both can, be on the same page with regards to the calculation of the guidelines. So again, that's the preferable method versus just duplicating worksheets, because if there are multiple worksheets for the same case, it gets confusing for judges and their designees to know which one to ultimately submit. So it's just best if we have one worksheet for each case. And there are a couple of different ways you can search. You can filter entirely by jurisdiction. You can search for the state identification number of the defendant, first name, last name, case number, or the worksheet ID number. So going back to the multiple criminal event, single sentencing event scenario that we talked about earlier, when that is the case, when you have multiple cases being sentenced in front of the same judge on the same day, you'll only want to click this add new button once to create one set of guidelines worksheets. So you don't want to create separate worksheets for each case number if they are a part of the same sentencing event. It needs to be one set. And if they are initiated properly, they will be linked by the same worksheet ID number. So I'm going to show you how to initiate that properly. So let's say we search the system. I didn't see the case that I need to initiate the guidelines worksheet for, so I'm going to begin by initiating it by clicking this add new button. You're always going to get this alert message here that says prior to adding a new worksheet, use the search feature to confirm a worksheet hasn't already been initiated. And again, only one worksheet should be created for multiple event or offense cases that are sentenced on the same day by the same judge. So I'm just
Hey, Catherine.
Yes.
Real quick, we're unable to see your screen.
Oh, okay. Thank you. Let me go ahead and try to. Let me try to fix that. Is that better?
Yep, we see it now.
Okay. So after you click the add new button here, you're going to be brought to the offender information tab first. And that's whether you're editing a previously initiated worksheet or initiating a new worksheet. So you can see we have MAGS divided into 7 tabs or screens, each of which represents a section of the guidelines worksheet. So offender information, pretty self-explanatory. This is where we're capturing the information about the worksheet preparer, as well as the basic demographic information about the offender. So I'm just going to begin by entering my name here as the worksheet preparer, and my agency is going to be other. And then I'm going to begin by entering the last name of the defendant, first name, middle name here, the state identification number. Also, just want to note that throughout MAGS, we have these information icons. So by clicking on the icon, it gives you a more detailed explanation of what each field is trying to capture. All of that information is taken directly from our manual. So again, if you ever have a question, definitely utilize these information icons. So state identification number here, sex, date of birth, whether a pre-sentence investigation is ordered, the jurisdiction, I'm going to select Anne Arundel. Let's say that it's represented by a public defender, ethnicity, no, and then race, which does allow for multiracial responses here. So then I'm going to click Save the Page in the lower right-hand corner, and you can either proceed by selecting the next tab header, or you can click Next over here. So moving on to the offender score, I'm going to go through this pretty quickly because I know we already went through all the criteria for each of these components here. Just want to note that the relationship to the criminal justice system when the instant offense occurred, that's scored at the offense level. Meaning when you go to enter that convicted offense information, that's when you're going to score that point, because it's possible for it to differ based on the date of the offense that you're entering. So you would then just enter juvenile delinquency, prior adult criminal record. Just want to show that this is a clickable hyperlink. If you click on it, it brings you to our prior adult criminal record matrix here, and our criteria for each record level is here as well. So there's no need to pull out our manual. So let's say that I initially scored this defendant to have a major record, but let's say that his prior criminal history meets the criminal record decay factor criteria, meaning that I can apply it. So if I want to apply that, I'm going to click yes, and you can see how MAGS jumps it down to a moderate for you. And then when you view the worksheet, you're going to see in red text and in parentheses, it's going to say decay factor, showing that the decay factor was applied. And then finally, prior adult parole and probation violations, we're going to score 0 here. So I'm going to click Save this page. and we're moving on to the list of offenses. So this is where you're going to enter all of the convicted offense information. And if you do have those multiple cases being sentenced in front of the same judge on the same day, this is where you can display all of that unique case number information. So I'm going to show you how to do that. You're going to begin by clicking the Add Offense button. And in the upper left-hand corner, we talked about making sure that the event number and count numbers are correct. So in this first offense I'm going to enter here, this is going to be a part of criminal event number 1. Now, when it comes to the count number, you're going to want to enter the count number that corresponds to the convicted offense on the indictment. It's so much easier for judges and their designees to compare sentence information and just look to the count numbers as they appear on the indictment that way. So please ensure that you're matching it with how it appears on the indictment. So let's say this is count number 3. I'm going to begin with the offense date, which is April 1st of this year. And you can see based on the jurisdiction that I selected on the offender information tab, it pre-populates, in this case with Anne Arundel County's MDEC format here. So following the C02CR, it's going to be a two-digit filing year. So it's going to be 22. And then there needs to be a 6-digit sequential number following that. So let's just say it's going to be 00 and then a 1122. No dashes. Now, convicted offense title, there's 2 different ways you can search. You can click this most common offenses button, which brings you to the 25 most common guidelines eligible offenses, or you can click the search button here, which brings you to our entire offense table. Now, once you get to the offense table, there's even a couple more ways you can narrow your search. You can search by offense title, the CJIS code, the statute, or the type, whether it's person, property, or drug. Now, I do want to note with regard to the statute, if the penalty of the offense is contained in a different portion of the statute than that of the offense description, you'll want to search for the penalty portion of the statute. This is very true when it comes to drug-related offenses, because a lot of times we get calls where people are trying to enter, 5-608 or 5-609, the criminal law article, which is where a lot of the drug-related offense descriptions are contained. But it's actually the penalty portion of the statute, which may be, let's say, like 5-620, something like that. So again, if you're trying to search by statute, you're having trouble, just keep that in mind, that you might want to search by the penalty portion. Also, a couple of different ways, also to search all of these columns simultaneously, you can do that by utilizing this search button in the upper left-hand corner here. So let's just say I'm trying to find assault 2nd degree. If I were to just type in assault, any offense that contains the word assault is going to populate here. And then I would simply click select next to the offense that I want. Once I do that, MAGS will populate the seriousness category, CJIS code, statute, and stat max here. If the offense involves an attempt, conspiracy, or solicitation, you would just make those selections here. If you're applying any sort of sentence enhancement, for example, if I click on the drop down here, you can see that these are disabled given the fact that they can't be applied towards this assault 2nd degree. But let's say you selected a drug-related offense, you would then see this subsequent drug offense, the range doubled, that sentence enhancement we talked about earlier. You could apply that here, as well as if you're charging with the defendant with a subsequent crime of violence and therefore subject to a 10, 25-year or life maximum, or if they're a repeat sex offender and therefore subject to the life maximum, you can apply those enhancements here. If you're flagging an offense for the multiple victim stacking rule, you would just simply select yes here, and then it would remind you of the scenarios in which you can apply the victim stacking rule. Now for this exercise, I'm not going to meet the criteria, so I'm going to go ahead and leave that as no. So jumping down to the offender score, I mentioned that relationship to the criminal justice system when the incident offense occurred. That's scored at the offense level, so you would then make your selection here. Once you make that selection, MAGS will calculate the total offender score for you. Now, assault 2nd degree is a person offense, so I need to jump over to the offense score on the right-hand side here and start making selections for victim injury, whether there was a weapon present, and if there was any special victim vulnerability. And similar, once I make those selections, the offense score populates here. Then I jump down and I click calculate guidelines range. Once I do that, the individual guidelines range for the offense calculates here, and then the overall guidelines range for the sentencing event will populate here. And then I'm going to click save this page and close. Let me just log out of that. All right, so there I have my convicted offense information for the assault second degree. So I'm going to quickly run through just entering 2 more convicted offenses. Now, these next 2 offenses, they're going to be a part of a separate criminal event. It's going to have its different offense date with a different case number. So I'm going to make sure I'm making this criminal event number 2. And this is going to be the first count in criminal event number 2. So this occurred a couple of months later on July 15th of 2022 here. It's gonna have the same filing year, but this is gonna be a different case number than what I just entered here. So I'm gonna click most common offenses, and I'm gonna make this a burglary first degree. And I'm gonna jump down and complete part A here. So no relationship when the instant offense occurred. Now, burglary first degree, it's a property offense, meaning I don't need to calculate the offense score. So I'm gonna jump down to the calculate guidelines range. And I'm sure you're all aware that we had several changes go into effect on July 1st with regards to the cell ranges for property and drug offenses. So you'll still see this alert message appearing noting that the guidelines for this offense seriousness category and offender score have changed and asking you to confirm whether the sentence date will take place on or after July 1st, just to ensure proper calculation of the guidelines. There are still some people going back and retroactively completing worksheets, which is why we still have this alert message in place right now. So just make sure you're entering it as appropriate. So I'm going to say yes, it's going to be sentenced after July 1 so that the new guidelines are reflected. And I'm clicking save this page and close. So you can see as of now, I have 2 criminal events, 2 offenses. They have their own unique case numbers here. So I'm just going to add 1 more offense to criminal event number 2. So this is still going to be criminal event number 2. It's going to be count 5 within that criminal event. So it's going to have the same offense date as what I just entered. And it's going to have the same case number as the one I just entered, since they are a part of the same case. So I'm going to go ahead and click most common offenses. And I'm looking for a theft related offense. So I'm just going to go ahead and type theft. And what I want is this felony theft or theft scheme, 1,500, but less than 25,000. So I'm going to go ahead and select this, make my selection for part A of the offender score, and then just click calculate guidelines range again, confirm that it's being sentenced after July 1, saving this page and closing out. Okay, so there we go. All right, now the last tab that's really completed by state's attorneys and parole and probation agent prior to sentencing is this victim information tab. So I mentioned earlier, these questions pertain to the rights of victims at sentencing. So we do ask that you complete as much information as you can pre-sentencing. That said, not all of these questions can be answered. Some have to be answered post-sentencing, and the judge or judge's designee will take that over. If there's no victim in the case, you would simply select no. All of these fields would populate as no. If there is a victim, you can select yes and just make your answers accordingly. So I'm just going to go ahead and make selections here real quick. And I'm going to say a no contact order was requested. And then I'm going to click save this page. Again, any question about what we're trying to capture here, just click that information icon and it'll tell you exactly what we're trying to capture. Okay, so at this point, I've completed all my convicted offense information. Everything's ready to go pre-sentencing. So to view the worksheet, you would then just click this view worksheet PDF button in the lower left-hand corner. And here we go. And this is where we can view the worksheets. I talked earlier about how criminal events correspond to their own worksheet. So that's why, since we have 2 criminal events, you'll want to scroll, and that's where you'll see your second criminal event populating here. And this you can save to your computer, you can print it out, take it to court with you, whatever is preferable. Now, the last thing I want to show before we wrap up on the MAGS demonstration, I talked earlier about how merged and null prost offenses, those should be deleted from guidelines calculation. Now, I know sometimes you may not know until after sentencing which offenses end up being merged or null prost. But again, a good habit to get into is making sure you're going back and deleting those merged or null prost offenses, just so the judges and their designees don't have any confusion when they go to enter sentence information. So jumping back to the list of offenses tab, let's just say this felony theft offense ended up being merged at sentencing. So to delete the offense, I would just simply click this delete icon next to the convicted offense. It's going to ask me to confirm that I want to delete it, and I'll say okay. Now, if the overall guidelines range happened to change as a result of deleting that offense, MAGS would automatically update that for you. Doesn't usually happen because the less serious offenses end up being merged or null prossed, but if it did, just know that MAGS would update that for you. And then you would simply click Save this page. Okay, so that wraps up the MAGS demonstration. Hopefully that was helpful, especially in determining how to appropriately initiate guidelines for those multiple criminal event and single sentencing event scenarios, because I know that those can be tricky. But it's important that they're initiated properly to ensure proper calculation of the guidelines prior to sentencing. All right, so I'm just going to wrap up with some upcoming updates, and then we will conclude. So just give me 1 second to pull the PowerPoint back up here. All right, so I'm going to quickly highlight 3 upcoming and notable updates to the guidelines. The first being at the Sentencing Commission's May 10th meeting, the commission voted to revise the offense type classification for arson first degree from a property offense to a person offense. So this reclassification means that arson first degree will now include the scoring of additional elements of a person offense, including whether there was victim injury, presence of a weapon, and whether a victim was a vulnerable victim. And the commission voted to adopt this reclassification to reflect the substantial risk of harm that arson first degree poses to dwelling inhabitants as well as first responders. If you received our e-news this morning, you'll know that this reclassification officially goes into effect tomorrow on October 1st of 2022. Also just want to note a revision to the scoring of juvenile delinquency. So as we discussed earlier, Part B of the offender score, juvenile delinquency, and instructs that points shall be scored for offenders younger than 23 years with findings of a delinquent act within 5 years of the date of the most recent instant offense. Now, effective October 1, 2022, again tomorrow, a revision will be added to the guidelines manual, providing the additional instruction that the juvenile delinquency record may not include adjudications based on acts that are no longer crimes. And this revision is consistent with the instructions for the scoring of Part C of the offender score at the prior adult criminal record, which states that the prior adult criminal record shall not include adjudications based on acts that are no longer crimes. So again, that goes into effect tomorrow as well. Now, the last update I want to highlight is regarding the collection of reconsiderations and modifications in 3-judge panel reviews. So just to provide a little bit of background, the Sentencing Commission is statutorily required to report annually on reconsiderations of sentences imposed under Criminal Law Article 14-101. And in recent years, some practitioners have expressed a little bit of confusion regarding the types of reconsideration scenarios that require a guidelines worksheet. Now, the guidelines manual, it doesn't include an explicit definition of reconsideration, nor is the term reconsideration defined by Maryland rule or statute. So in collecting sentencing guidelines worksheets, the commission's taken a broad approach in an effort to capture eligible modifications to crimes of violence, generally instructing that in addition to original sentencings and new trials, a worksheet should be completed for any modification to the active sentence for a crime of violence, including those that result from Health General Article 8-507 orders, as well as 3-judge panel reviews. So in an effort to reduce misreporting that we've been seeing in MAGS, at its July 12, 2022 meeting, the commission voted to limit the collection of worksheets for 3-judge panel reviews to those involving crimes of violence. So this change provides consistency with the data collection protocol and reporting requirements for reconsiderations and modifications. And additionally, the commission also agreed that the term modification is a more universally understood term, and that clarifying the term reconsideration by adding modification would help bring further understanding as to the types of sentencing scenarios involving crimes of violence that require a guidelines worksheet. And MAGS will also be reprogrammed to help further identify the type of modification involving a crime of violence. So just to reiterate, even though there's no change regarding the rules of guidelines eligible cases as they relate to reconsiderations and modifications, clarifying language will be added to the manual indicating that guidelines eligible reconsiderations slash modifications include sentence adjustments imposed pursuant to Maryland Rule 4-345 or a Health General Article 8-507 order. So just to give you all a heads up, this clarifying language is set to go into effect on November 14th of 2022. All right, so wrapping up with some resources here. Just want to note our main website, www.msccsp.org. It's continually updated throughout the year. It's a really useful resource for those individuals who implement the sentencing guidelines. The website also includes those annual reports that I mentioned earlier, all of our guidelines e-news, which helps to inform about any changes related to the guidelines. If you don't subscribe to our listserv, but you'd like to, please just send us an email to our general email account and ask that you be added so that you get these guidelines e-news. I'll give you that email address at the end here. Also, just want to point out that more recently we started production of a series of topical mini reports that we've titled Sentencing Snapshots, which are intended to provide a quick review of sentencing trends and other topics of interest. So here's a screenshot of the most recent issue of the Sentencing Snapshot, which provides a closer look at sentencing trends in Maryland circuit courts for murder. All of these sentencing snapshots are available on our website. Again, if you subscribe to our listserv, you'll also get these via email as well. And just a shout out to my colleague, Sarah Bowles, who puts these together. She does a fantastic job, and we've gotten a lot of positive feedback in response to them. Just also want to note our guidelines manual and guidelines offense table is available in PDF format on our website. You can also access MAGS and the guidelines calculator tool. We have several instructional and support videos, as well as guideline training webinar videos that you can view from our website. Here's a screenshot of our training page where you can view those videos. Any upcoming webinars are also going to be advertised here, and you can certainly register for those. We also have a YouTube channel. If you just go to YouTube and plug in MSCCSP, you'll see all of our guidelines related videos populate there. Finally, you can always feel free to contact us over the phone at 301-403-4165 or via email at msccsp@umd.edu. If you call or email us, you'll most likely reach me first. Catherine, the coordinator, many of us probably have spoken. So always feel free to contact us with any guidelines related questions. So that wraps up the webinar. I just want to check in with Stacy and Sarah to see if we have anything outstanding that needs to be addressed before we conclude.
We do not have anything outstanding. No outstanding questions were posted.
Okay, great. Thank you. All right, well, thank you all again for attending today's training. I know it was a lot of material, but hopefully you found it informative. And again, you can just walk away feeling a little more comfortable about the guidelines calculation process. So again, always feel free to contact us. And with that, we hope you enjoy the rest of your day. Thanks so much.